Welcome to the Greenville Technical College presentation of the Families First Coronavirus Response Act Overview for Supervisors. This video will equip you with the knowledge that you need to supervise your employees who may be impacted by the COVID-19 pandemic and the recent FFCRA legislation. The objective of this training is to provide Greenville Technical College supervisors with a general understanding of the Families First Coronavirus Response Act, which was signed into law on March 18, 2020, and took effect on April 1, 2020. The FFCRA and its two associated leave acts, Emergency Paid Sick Leave Act and Emergency Family and Medical Leave Expansion Act, provide temporary relief to eligible employees affected by the COVID-19 pandemic. Emergency Paid Sick Leave Act, commonly referred to as EPSL, provides up to 80 hours of paid sick leave for employees for 6 qualifying reasons related to COVID-19. Emergency Family and Medical Leave Expansion Act, commonly referred to as EFMLA, expands the Federal Family and Medical Leave Act to provide leave for employees who are unable to work, including work from home, as a result of having to care for a minor child due to a COVID-19 related closure of a school or child care center. EFMLA and EPSL should only be used by employees if the employee is unable to work and the agency has exhausted all work-from-home opportunities which may exist. Let's take a deeper look at the Emergency Paid Sick Leave, or EPSL provision of the FFCRA. Who is eligible for EPSL? EPSL applies to any public agency, including all South Carolina state government agencies and institutions. This includes employees who do not currently earn leave, including temporary grant, and time-limited employees. Employees are eligible from their first day of employment. How many hours of paid sick leave can be taken? Full-time employees, those who are regularly scheduled to work 40 hours per week, are entitled to 80 hours of paid leave. Part-time employees, including employees in part-time FTE positions, are entitled to paid leave for the number of hours equal to the number of hours that such employees work, on average, over a 2-week period. So what are the qualifying reasons for emergency paid sick leave? Reason 1. The employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. Governor McMaster's executive order requiring that all non-essential state employees not report to work constitutes a federal, state, or local quarantine or isolation order related to COVID-19. Therefore, all employees who are unable to work from home and have been ordered not to report to the work site would qualify for this leave for the duration of the order. Reason 2. The employee has been advised by a health care provider to self-quarantine due to concerns related to COVID-19. Reason 3. The employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. Paid sick leave taken for this reason must be limited to the time the employee is unable to work because he or she is taking affirmative steps to obtain a medical diagnosis. Thus, an employee experiencing COVID-19 symptoms may take EPSL, for instance, for time spent making, waiting for, or attending an appointment to test for COVID-19. But the employee may not take paid sick leave to self-quarantine without seeking a medical diagnosis. An employee who is waiting for the results of a test is able to work from home, and therefore may not take paid sick leave if A. his or her employer has work for the employee to perform, B. the employer permits the employee to perform that work from the location where the employee is waiting, and C. there are no extenuating circumstances, such as serious COVID-19 symptoms, that may prevent the employee from performing that work. Reason 4. The employee is caring for an individual who is subject to an order as described in Reason 1 or has been advised as described in Reason 2. Please note that the person being cared for does not have to be related to the employee for the employee to qualify for leave. The qualifying reason applies if the employee is unable to work, including work from home, due to the need to care for the individual. The employee must have a genuine need to care for the individual. Paid sick leave may not be taken for care of someone with whom the employee has no personal relationship. Rather, the individual being cared for must be an immediate family member, roommate, or a similar person with whom the employee has a relationship that creates an expectation that the employee would care for the person if he or she self-quarantined or was quarantined. Reason 5. The employee is caring for the son or daughter of such employee if the school or place of care of the son or daughter has been closed, or the child care provider of such son or daughter is unavailable due to COVID-19 precautions. Child care provider includes a center-based child care provider, a group home child care provider, a family child care provider, or other provider of child care services. In addition, the FFCRA does not require that a child care provider be compensated or licensed to meet the definition of child care provider if he or she is a family member or friend, such as a neighbor, who regularly cares for the employee's child. Reason 6. The employee is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services in consultation with the Secretary of Treasury and the Secretary of Labor. The amount an employee can receive through EPSL depends on the reason for the EPSL leave. Qualifying reasons 1 through 3 are paid at the employee's regular rate of pay up to $511 per day or $5,110 in the aggregate. Qualifying reasons 4 through 6 are paid at 2/3 the employee's regular rate of pay to $200 per day or $2,000 in the aggregate. In such cases, employees can use any accrued leave to augment leave taken pursuant to the Emergency Paid Sick Leave Act up to the regular salary rate. Next, let's take a closer look at EFMLA. The EFMLA amends and expands the Federal Family and Medical Leave Act, FMLA, on a temporary basis to provide qualifying employees 12 weeks of leave if the employee is unable to work, including work from home, due to the need to care for the employee's child, under 18 years of age, if the child's school or place of care is closed or the child care provider is unable due to a public health emergency. Unlike EPSL, EFMLA is limited to this one qualifying reason related to child care. Note that employees are limited to a combined total of 12 weeks of leave taken under the EFMLA and FMLA during a calendar year. If an employee has already taken 12 work weeks of FMLA leave during the applicable 12-month period, they may not take additional leave under EFMLA. Who is eligible for EFMLA? Employees are eligible to take leave under the EFMLA Act if they have been employed at least 30 calendar days. This includes employees in non-FTE and non-leave accruing positions. If the employee has worked as a temporary, time-limited, or temporary grant employee and was then transitioned to an FTE position, the total time worked in both positions should be added to determine if the 30-day time frame has been met. Is EFMLA leave paid or unpaid? The first 10 work days of the 12 work weeks of leave provided under the EFMLA are unpaid, but in accordance with the standard FMLA administration, employees may use any paid leave available concurrently with EFMLA during this 10-day period. This may also include EPSL. After the first 10 work days, paid leave must be provided for the remaining leave taken under EFMLA. This includes leave taken by employees who do not currently earn leave, including temporary grant, and time-limited employees. Is the leave paid at the employee's regular rate of pay? The paid leave provided to eligible employees is calculated at 2/3 of an employee's regular rate of pay and should be based on the number of hours the employee would otherwise be normally scheduled to work. Paid leave under the EFMLA is capped at $200 per day and $10,000 in the aggregate. Employees can use any accrued leave to augment leave taken pursuant to the EFMLA up to their regular salary rate. We will now address a few common questions from supervisors related to the FFCRA and associated provisions of EPSL and EFMLA. How does emergency paid sick leave and EFMLA leave work together and with other types of leave available to employees? While each employment situation is different, we will provide a simplified sequence of leave taken by a typical employee beginning April 1st. This is assuming the employee is not considered critical and cannot work from home. Employee begins EFMLA leave, and the first 10 days are unpaid. The employee takes emergency paid sick leave available under the FFCRA concurrently with these first 10 days. Beginning on day 11 of the EFMLA leave, the employee receives pay in accordance with the provisions of the EFMLA subject to applicable daily and aggregate limits. The employee may use other leave types to make up the difference in the benefit provided under the EFMLA and the employee's regular salary if necessary. When the maximum amount of paid EFMLA leave is received by the employee will continue EFMLA leave for the remainder of the eligible period, but this time the employee will not be paid under the EFMLA. Employees may use leave, i.e. sick leave, advanced sick leave, compensatory time, holiday compensatory time, and annual leave for this unpaid period. This paid leave will run concurrently with the EFMLA leave. This is consistent with the current rules surrounding FMLA and leave. The employee may be advanced sick leave for use during the period of unpaid EFMLA leave in accordance with Division of State HR guidelines. What should I do if my employee makes me aware of a situation that may qualify under FFCRA or expresses a need for leave under FFCRA? If you have an employee that may be eligible, please submit the FFCRA supervisor form as soon as possible. Likewise, if you have employees that have been prevented from working, including telework from home, that may qualify, please encourage them to submit request forms for consideration, particularly when you know they are not regularly monitoring GTC email or other means of communication. EPSL and/or EFMLA must be requested by employees, and supporting documentation must be provided as outlined on the request form. Employees who are prevented from working, including telework from home, due to a qualifying reason associated with COVID-19 may submit a completed request form for consideration. FFCRA associated forms are in the document repository on Resources for Me under Human Resource Documents. You may also contact the GTC Benefits Counselor at 864-250-8704 with any further questions. Can an employee refuse work, including work from home, provided by the agency and use EFMLA or EPSL leave? No, unless the grounds for the request prevent the employee from working, including working from home. As an example, an employee may only take paid leave due to a federal or state quarantine or isolation order, EPSL Reason 1, if being subject to one of these orders prevents him or her from working or working from home. According to the DOL, an employee may not take paid sick leave if 1. His or her employer has work for the employee to perform, 2. The employer permits the employee to perform that work from a remote location, e.g. where the employee is self-isolating, and 3. There are no extenuating circumstances that prevent the employee from performing that work. Therefore, an employee may not take FFCRA leave simply because he or she prefers it to the work-from-home opportunities provided by the agency. But instead, an employee may only take FFCRA leave if one of the qualifying reasons for leave prevents him or her from performing the work offered. What is an appropriate use of accrued sick leave during the COVID-19 event? The sick leave laws and regulations in South Carolina exist to promote public health and to prevent the spread of contagious illness in the workplace. Therefore, if individuals fall into CDC-defined higher risk or special populations, or are otherwise affected by social distancing directives related to COVID-19, they can use sick leave to cover their absences from work if they are not telecommuting eligible and their agency leadership determines that their presence at work is not required. Similarly, sick leave may be advanced, in accordance with DSHR guidelines, to employees that fall into the CDC-defined higher risk or special populations or are otherwise affected by social distancing directives related to COVID-19. Use of sick leave is not appropriate if an employee wishes to take time off from work for reasons unrelated to illness or a doctor's appointment. whether that illness is COVID-19 or another illness. Such an employee should use accrued but unused annual leave, faculty non-work days, floating holidays, compensatory time, or holiday compensatory time for such purposes. How should time and attendance records be maintained for my employees during this pandemic? Non-exempt employees must record time daily in Kronos, even when working remotely. Managers should be regularly monitoring employee time in Kronos for leave-eligible employees to ensure that work time plus any approved leave or leave without pay equals the employee's regularly scheduled hours each week. Employees that are eligible for EPSL or EFMLA on or after April 1st should use this leave first before utilizing other available accrued leave. Please note that approved EPSL/EFMLA time will not appear in Kronos until approved. If someone is approved for EPSL/EFMLA and another type of leave has already been submitted in Kronos, Mary will adjust Kronos so that the accrued leave balances are restored accordingly.